Right. Good morning, and thank you for joining myself and also my colleague, Patrick Windhorst. Pat Windhorst is the four-term elected state's attorney of Massac County and has significant experience in the criminal justice system. And as many of you know, that I was an assistant Cook County state's attorney at 26 in California for a number of years. Last night's decision is a victory for the citizens of Illinois and specifically victims of crime and the men and women of law enforcement. We warned about the consequences of the legislation from the beginning. Now the Illinois Democrats, the governor, the president of the Senate, and the Speaker of the House are feeling the consequences of how they formulated and passed this legislation. After 4 attempts to fix this misguided and confusing scheme and a strong rebuke by the circuit court, we have an opinion that we have to now decide how it's going to work and how this is going to be applied statewide. My recommendation is that we have both parties, the prosecutors and also the state, seek a stay of the implementation of the Pretrial Fairness Act section of the Safety Act to the Supreme Court and negotiate in good faith to find a fair and reasonable cash reform bill. Or I would ask that both parties, the plaintiff, the prosecution, and also the governor, the speaker, and the president, to stay the implementation of this act while this matter is under appeal. We have 54 counties that are affected by this. And we now will have, if nothing is done between now and January 1st, there will be unequal application of this law throughout the state of Illinois. That is not right. It's not responsible. So I'm ready to now pass it over to my colleague, Pat Windhorst.
Thank you, Leader Durkin. Patrick Windhorst, State Representative of the 118th District, and I also would like to join with Leader Durkin in applauding last night's decision out of Kankakee County. Last night's decision validated many of the arguments that myself and others have been making over the last 2 years regarding the constitutionality of the Pretrial Fairness Act portion of the Safety Act. I'd also like to thank the bipartisan group of state's attorneys and sheriffs who came together and each filed these lawsuits to bring this effort forward and to make sure that last night's opinion was possible. The court in its ruling made clear the ability for a court to set monetary bail is inherent in the judicial power of the court and is provided by the state constitution. That is something many of you here have heard us discuss over the last 2 years. In order for that inherent power of the court to be amended or taken away, it must come through the proper process, which is amending the Constitution rather than legislation. As the court made clear, bail is the middle ground to strike a balance between the defendant's right to potential release prior to trial, as well as the requirements of the criminal justice system to assure the defendant's presence at trial and for the protection of the public. The Safety Act, as we have said, limits judicial discretion by eliminating cash bail, and this opinion makes that clear. So we are here now with potential chaos that may ensue beginning January 1. We will have counties throughout the state which will have a cash bail system, and counties throughout the state which will potentially not have the cash bail system or it will be eliminated. We will also see after January 1st, defendants who are held without cash bail appealing those decisions, and those appeals will work their way through the appellate court system. This was avoidable. Myself and others during the during the veto session had argued that the pretrial fairness portion of this act should be delayed pending this ruling and pending appeal to the Illinois State Supreme Court potentially. Instead of doing that, we will now have chaos beginning January 1st throughout the state. Unfortunately, this is going to occur, but it was avoidable.